Hey everybody, good evening. How y'all doing today? I'm doing okay. I'm a little under the weather, so if I have a cough, I apologize. I'm got a little sick, but let's get started. So today I wanted to go over a hearing that I shared on the Hidden Horror Facebook page. The hearing is about it's a preliminary hearing for a man. In this case, it's out of the state of Michigan. And the man allegedly did an S assault. I'm showing you and I'm bringing you the video. I want you to watch the entire video when you have a chance, even if you can't do it today. It's an excellent video to watch. The judge, her name is Elaine Washington, and she does a pretty good job trying to preserve the defendant's rights, but also being fair to the prosecutor and defense. Remember, the preliminary is going to have potential witnesses from the prosecution and the defense. They can both put evidence on at that hearing. Excuse me. So I want to show you that parts. You can watch the whole video, but I will play just small snippets from the hearing so that you can hear some of the points that I highlight. But I really want you to watch the video because the victim, she's an excellent witness. She is prepared. She answers clearly. She details her story. When she's cross-examined by the defense attorney, she gives an excellent picture of what happened to her allegedly, and she holds her composure. It's a pretty sad case. I don't want to state so much of the details because I don't really like to highlight the victims so much. I like to kind of keep their identity quiet or protected a little bit, but it's really excellent video. The hearing was held on Zoom, so still a lot of court hearings and motions are held on Zoom. So the hearing was held on Zoom by the defendant's request. They could have went in person, but he asked to have the hearing held on Zoom. And there's a few things that come out in the hearing. So I would just advise you, if you're sensitive to hearing about details of an S assault, or if you have any prior issues with hearing um, details of a threatening manner, then maybe that is not the video that you want to watch. And you can just listen to me kind of go over parts of what happened at the hearing. But the hearing is about 1 hour long. And to me, it's an excellent example of how a witness should testify, that they should stick to the facts, how they should be detailed. If they're able to, just answer yes and no. At a hearing, you want to dress professional. You want to speak clearly. Um, you really just want to appear that you're prepared and you're able to discuss in detail what you allege happened to you. So she did an excellent job. So I just want to highlight that. I want you to watch that video. So let's talk some more details. Okay. So allegedly, back in March of 2023, the victim was staying at a house. The suspect came at the early morning hours and got into her room that she was sleeping in that night into the early morning. She pretty much went to bed um, after 2 a.m. And he came into the room, and that is where the S assault allegedly occurred. Now, the victim, she did a great job immediately taking the clothes off. She went to the bathroom, locked the door. She called a friend that was able to come to pick her up, and she asked that her friend take her to the hospital, that she felt she was assaulted and she wanted to be seen by a doctor. She took those clothes off, she went to the hospital, and thus the case and the beginnings of everything in the criminal justice system began for her. So now she is a witness in the case, and she's actually testifying at the preliminary hearing. Okay. Now, There's some terms that we have to go over because I never want anybody to feel like they don't understand what I'm saying. So one of the words, so when I say witness, this is what a witness is. It's one who sees, knows, or vouches for something. One who gives testimony under oath or affirmation in person, by oral or written deposition, or by affidavit. So again, she is the victim, and she's also in this capacity being a witness, and she's going to detail what she alleges happened to her this early morning hour. Okay. Now, when the suspect, when he was arrested, he was released on what's called a bond. So a bond is an obligation or promise. It's a written promise to pay money or do some act if certain circumstances occur or certain time elapses, a promise that is defeasible upon a condition subsequent. So, in layman terms, a bond is the ability for a person to put up money or property in in exchange for you being released. So in his case, there was a bond set. For example, if the bond is $100,000, usually a bail bondsman will take 10% of that. So that would be $10,000. And then in exchange for that, you would be released. But there's conditions to a release. So usually in S assault cases, one part of that condition or list of conditions, it will be not to contact the victim. Do not contact the victim. Do not try to see the victim. Of course, if you're not contacting the victim, there can be no exchange, but you can't call them on the phone. You can't see a person. You can't threaten a victim. You can't try to maybe offer, like, bribe them not to testify or, not to be a witness in the case. So he was released on bond, the suspect. Now, there is an allegation at the hearing. This is a separate part because the preliminary hearing is just putting on evidence to see if there's enough details, information, facts. And the standard is a probable cause standard. So that's a pretty low standard. Is there enough information there? Is the witness believable? Is what they're saying believable? Do they have any supporting evidence, any reports to the police? Did they go to the hospital? Did they get an R kit done on them? Was there any witnesses at the scene in the house? Did they reach out to anybody? Did they receive any services? All of that will be considered. And is there enough of that going on that is clear that a possible crime occurred? So in this instance, the preliminary hearing was supposed to have all of those things come out, and then a determination would be made if there was enough evidence to proceed with charging and prosecuting the suspect. Excuse me. So when all of the hearing is going on, it comes to be said, and I believe the prosecutor, her name was Amy Reiser. She wanted to also discuss a potential bond violation. So remember, we already talked about what the bond is. The bond is the ability for a defendant to be released from prison, but there's going to be conditions, and something has to be put up, whether there be property or money. Some people are released on their own recognizance. But in this case, there may have been a bond because of the charge being a violent charge, because of the S assault charge, right? Anyway, the important thing is when the testimony is going on, the prosecutor wants it to be known to the judge that there has been a bond violation. So what does that mean? A bond violation is something that occurs out of those stipulations of things you're not supposed to do. For example, contacting the witness, threatening the witness, trying to bribe the witness, different stipulations, right? Well, in this case, they're alleging that the suspect sent or has someone else send threatening messages through text to the victim. And those messages were supposed to put her allegedly in fear so she would not attend the preliminary hearing. She would be so fearful of being harmed that she would not attend the preliminary hearing. So the prosecutor brought that up and said that due to that behavior that is linked to the bond, which means this defendant allegedly violated the conditions of the bond. Now, if you violate the conditions of the bond, the judge has a lot of different options. You could be warned. You could have your bond taken away. You have to turn yourself in and go back to prison. Um, you could possibly be put on a tether. I'm not sure how effective a tether would be in this case because the threats are through text message. Um, I guess if the judge felt that he would carry out the threats, because initially, allegedly, the threats were coming from the suspect's cell phone number. As the time went on, as the case moved through the system, the threats were coming from a different number. But initially, the initial threats were from allegedly the suspect's phone number. So all of that got brought in the preliminary hearing, and the judge actually decided to address that issue. Okay, so let's talk a little bit more about some of the parts I want to play. Remember in some of the past videos, I have kind of shown you a pattern, right? How assault offenders, how they behave. Most of them, they try to do things when they feel they would not get caught. So they will see an opportunity and they feel they won't get caught and they will take it. They may offend late at night because they feel that no one can see them or people may be sleeping. Um, they just figure out when is their opportunity to attack. They may feel that someone has been drinking and maybe they don't have the ability to fight back, or they may not remember what's happening to them. It could just be so many different scenarios, but they're always looking for an opportunity where they feel is less likely that they will get caught. Now, in this incident with the victim, it was late at night, early in the morning, after 2 a.m., and she was in the bed, and everyone else that was actually in the house, they were asleep. The person where she was sleeping in their bedroom, they were gone. So typically, she's sharing a bed with a child, or she's sleeping on the sofa, which is probably in an open space. But by her going to a bedroom where there was no other person there with a door closed, that gave him the ability to feel he could go into the room and no one would see him. And by the child that's bedroom it was, that child wasn't there. So it would just be her alone. So this again is an opportunity for these S offenders. They feel they can get away with it. They can quietly sneak in. It will be your word against their word. They could even say, "Oh, I was drinking. I didn't know anyone was in here," or, my mistake, something like that. So it could be dismissed. But this woman, this victim, she was her testimony was very forthright, clear, strong. Sadly, very sadly, she was actually pregnant at the time of the assault by her boyfriend. She didn't live with her boyfriend, but she does have a connection to him, seeing him, and she was pregnant by him. So let's continue. Um, I want to let you know that prior to the preliminary hearing, and a lot of people, they may not know this, they're not involved in any type of legal proceedings, or they don't have anything to do with court dealings, but the majority of cases, they do not go to trial. Many people do not feel that they have maybe the finances or the adequate representation to go through an entire trial. Some people have fear that if they go to trial, they will get a harsher sentence. Some people maybe do not want the facts to be known of what happened. For example, in assault cases, typically when there's an assault, it is done by force. It can be violent. The person could be fearful, and when they get on the stand, they may receive some sympathy because they may have some emotional problems after the assault. Sometimes they have to seek counseling for their mental health. Sometimes there is bruising, injuries. It could just cover so much. And the S offender, they really do not want the victim to testify, to get on the stand and describe in detail. And when I'm saying detail, very graphic detail. You don't just get to say I was assaulted. They want to know when, how did it happen, how did they touch you, where did they touch you, how did they rip your clothes. I mean, very, very details. This will typically put the jury in an uncomfortable position because they're hearing very graphic details of the assault. And it tends to make the suspect uncomfortable. They do not want the jurors to hear what has happened. So they will plead guilty. They may even get a plea bargain. Excuse me. Apologize. My apologies. They may receive a plea bargain deal from the prosecutor prior to the preliminary hearing. Now, let me give you the definition of what a plea bargain is, because that's important to know that. A plea bargain. A plea bargain is a negotiated agreement between a prosecutor and a criminal defendant whereby the defendant pleads guilty to a lesser offense or to one of multiple charges in exchange for some concession by the prosecutor, usually a more lenient sentence or a dismissal of other charges. Excuse me. Excuse me. So in this case, the prosecutor offered the defendant a plea bargain. And let me read to you what it was. The plea bargain was to reduce the charge to an assault with intent to commit as penetration. Now, in the actual testimony of the victim, she said that she was assaulted and she was penetrated. So, if that is true, this is a lesser charge. Remember, this is an attempt. So this is a reduced charge. Now, on the plea bargain, he was offered 1 year in prison. He would have probation, and he would have to register as a S offender. Okay, so 1 year in prison, probation, and he would have to register as a S offender. Now, in my opinion, if I had to recommend anything in this case, I would recommend, if that was my client, to take the deal. And the reason being is, if the suspect is found guilty, he may be enhanced because, again, the victim was pregnant at the time of the assault. And the jury may feel that that could be very harsh for the victim to have to go through. And also the judge, right, when they do the sentencing. So 1 year in jail, probation, and you have to register as a S offender. To me, that is not that harsh. However, I guess the suspect, he talked to his attorney and he rejected the deal. So let's hear some of that. Okay, let me get the hearing up. So I want you to hear that.
Period. At this point in time, I am not willing to adjourn this matter any further.
Thank you, Your Honor. Also, for the record, I believe there was an offer in this matter to reduce the charge to assault with intent to commit criminal sexual conduct. Is that correct, Ms. Reiser?
Correct. The offer was plea to an added count 2 of assault with intent to commit sexual penetration with a sentence agreement of 1 year in jail, probation, and the sex offender registration.
I have gone over that with that offer with Mr. Hill, and he is rejecting that and choosing to go to exam this afternoon, understanding that once rejected, an offer is off the table and doesn't have to come back.
Correct. And I also, at the conclusion of the exam, would like to address the issue of bond.
Thank you. Mr. Hill, you understand that an offer has been made to you today, and that if you are rejecting that offer and you proceed to preliminary examination, it is Ms. Reiser's position that you will no longer be receiving that offer in the future. Do you understand that, sir?
Yes, I do.
All right.
Okay. Excuse me. So I just wanted you guys to hear how the judge, she took the time to go and confirm that the suspect had the intention of not accepting the offer. She didn't just take his attorney's comments. She asked him so it could be on the record, which is really wise, because if later on he has any issues, it will be on the record, in his verbal response, and the Zoom video will show that he rejected the prosecutor's plea deal, which I think was a very nice plea deal for what he allegedly did to this victim. Okay. So initially, early on in the hearing, the threats to the suspect were brought up. So I'll play a little bit of that. This was in the first about 2 minutes of the hearing. Okay.
At the bench, the people are objecting to an adjournment. The case has been adjourned from May 27th and again from June 17th until today's date, July 20th. I do believe the public defender has had ample time to prepare for the exam, meet with the defendant, and I believe in light of the threatening messages that the victim has been receiving, I believe that the request is coming because the defendant thought that the victim would not appear for the preliminary exam based on the threats that she's been receiving from him. So we're here and we've been ready to proceed since 9 o'clock.
Okay, so I just wanted you to hear that from the onset, the prosecutor was right on target, letting the judge know from the gate that this victim, she is being threatened by the suspect or someone that the suspect has asked to send those text message threats allegedly. Okay. I do want to notate something. The meeting was held over Zoom by the defendant's request. When the suspect came onto the Zoom, I'm not sure if the judge had a requirement for attire, but the appropriate attire would be something where your arms, your chest is covered. he had on a t-shirt, which I felt was inappropriate for court. And during the hearing, especially in the beginning of the hearing, it appears that the suspect was holding a video game controller. He was not focused on the hearing. He was kind of looking, appears to be maybe at a TV and playing a video game. So it was very disrespectful to the court. Okay. I want to have you guys listen to a little bit of the suspect's attorney. He had an issue with the hearing being held on Zoom because there was some internet connection issues. And he actually brought them up, even though he was the party that asked for the Zoom hearing. So I want you to hear some of that. So let me go to that.
And in between me waiting for the place that I'm currently in to be ready, I was staying with me.
Okay. And where do you work at that you knew Aaliyah from work?
I work for Ypsilanti Community Schools.
Okay. And while you were staying there, did you?
Your Honor, I believe that her Ms. Nelson's camera went out.
I believe it did as well.
I was trying to get it back.
One moment, please. Ms. Nelson, one moment, please. That sometimes the camera does have to go out in order for the video feed to actually be able to take up to hear the testimony. So it may have to occur in this environment, Mr. Gaddy. Are you objecting to that?
Yes, Your Honor. I mean, we're on Zoom, which is, great technology, but I still think we need to be able to judge body language and things like that.
Any response? Ms. Reiser?
No, Your Honor. I mean, I think it's a bandwidth issue. So I think when she's speaking, we're not able to hear her. But if she's able to share the screen, then we can hear what she's saying because of the internet connection.
I believe that the prosecution is correct with respect to that. So, yeah, if your client hearing via Zoom without objection, he did schedule it for a Zoom hearing, correct?
He did.
That is correct, Your Honor. I believe it is scheduled here via Zoom.
All right, thank you.
However, it's scheduled via Zoom working properly. Zoom in the vast majority of cases entails, it's different from a telephone in that we can see each other and hear each other both at the same time. Technology that we didn't have a couple of years ago for the most part. So to the extent that he did it, I believe this was scheduled for a Zoom exam. However, I don't think that it was scheduled for a phone exam, which is what this turns into if the camera isn't working.
Well, Zoom can actually be via phone. People can call in. So technically, she could have called in today and testified.
I'll just note my objection, Your Honor. Like I said, I don't know if her not being. Zoom is typically people being on the screen. Testifying without that, it becomes not that. And if this is, if the standard for a Zoom exam is that she could have called in and testified without any facial or without any camera, then I don't necessarily know that we would have waived to that, or we would have agreed to that.
All right. Additionally, I can't see your client either because he's in the dark.
Can you turn on the light, Mr. Hill? There we go.
Thank you.
And he's sideways. I don't know what's up with that.
All right, thank you. We will continue to try to see if we can get the testimony so that I can hear her. If we are unable to hear her and there is an objection to seeing her, then we may have to have this done in person. It's the only thing I can think of.
Okay, so I just wanted you guys to hear that the defendant's attorney, he actually complained about the Zoom, even though his client is the one that actually requested the Zoom hearing versus the in-person hearing. And again, you could not visibly see his client. He was in a space that it was not a lighted space, so you could not see his face. And again, he appeared to be playing a video game at the time of the hearing and during the hearing, throughout the hearing. So I wanted you to hear that. I really hope you can go watch the video. It's interesting. So I want to go to one of the things that I said earlier, which was this is a point in the hearing where the victim revealed that she was pregnant, okay? So if you're sensitive and you're not able to, safely hear this information, please, check off the video. Give me 5 more seconds. Okay, I'm going to start playing it now.
I think it was like an off-term living situation. He was there quite often, but I wouldn't say as often as I was.
Okay. And so Saturday evening, May 1st, going into the early morning hours of Sunday, May 2nd, can you tell us what you were doing at the residence?
At the rest of that time, I had come in from spending the day with my child's father. I guess I just took a shower that day. I went into the bedroom to go to bed. The bedroom being that of Aaliyah Taylor's, her son. He had went to spend the night with a family member, which left his bed free and available. I usually slept on the couch or with Aaliyah Taylor's daughter. So opposed to sleeping in bed with another person or on the couch, I decided to take her son's bed.
And he was gone for the night?
Yes, he was gone for the night.
Okay. And when you say your child's father, can you explain who your child is?
I am currently pregnant. I'm 27 weeks tomorrow. So when I say my child's father, the man who impregnated me, that's who I'm referring to.
Okay. And so you mean your unborn child?
Yes, my unborn child.
Okay. So you went to bed in...
Okay, so I wanted you guys just to hear she was pregnant at the time of the alleged assault. Okay. I'm going to move a little bit ahead. There's a point when the defendant's attorney, he makes an objection and he calls the testimony hearsay. So I want to give you the legal definition of hearsay, and I will play that out and some other things out. But let me give you the legal definition of hearsay. Traditionally, testimony that is given by a witness who relates not what he or she knows personally, but what others have said, and that is therefore dependent on the credibility of someone other than the witness. Such testimony is generally inadmissible under the rules of evidence. Okay, so he makes an objection and says testimony is hearsay. However, it's not hearsay, cannot be hearsay, because everything happened to her. She is the witness and the victim. So her testimony is not hearsay about what happened to her. But for some reason, the defendant's attorney oddly makes this objection. Now, maybe it's to interrupt her, possibly, maybe to throw her off, to get her. He abruptly interrupts her throughout her testimony. I don't know if he was trying to shake her up or what, but allegedly, this is not typical. Most attorneys know what hearsay is. They're familiar with hearsay. She's giving her own firsthand account. So I'm not sure why he made this objection, but I want you to hear it. And then I will take a quick pause and I will set a segment that I want you to hear. So let me go to that.
Cause penetration.
Okay, and so at that point, did he have you on your back?
Yes, ma'am.
Okay, and what, if anything, is he saying to you?
He is, in the beginning, there wasn't much that was to be said by the defendant, but as I started to tell him, no, I don't want this isn't what I want, stop. He started to ask me very specific questions. Do you like it? How does this feel? Things like that.
What's the objection?
Good. Objection to hearsay?
Yes.
All right. The objection is hearsay.
Your Honor, that's a statement made by a party opponent, specifically the defendant in this case.
Thank you. I agree. Overruled.
Thank you.
Thank you, Your Honor.
So you're telling him,
Okay, so if you watch this video, the prosecuting attorney, she is looking super confused. Like, what? Like, why did he object to it and say it was hearsay? Because she is the victim and the witness. The account is about the encounter that allegedly happened. Excuse me. So it was weird. It didn't make any sense. So anyway, let's move forward. I want to play. This will be about maybe 2 minutes that I'm going to let you listen to. I want you to hear how clearly detailed this victim is. She describes the next steps of what she did, how she handled things. I may let it. There's a point where she says she believes the suspect was drinking, but that's not even important, really. But I want you to hear her account of what she did after the alleged assault. She clearly details her thinking, what she did next. And I think she was just an excellent witness. So I want you to check out that video that I did talking about how to be a witness, how to prepare for court. So when you're cross-examining, when you're testifying, you are perceived as honest, truthful. Your statements are clear. You're giving yes and no answers. You're responding to the questions as asked, etc. So I want you to hear her testimony. Okay. So I back it up just a little bit. Okay, here it is.
My clothing. I changed my clothes. I went and I locked myself into the bathroom. I texted a best friend of mine and told her that I needed a hospital and that I felt I had just been assaulted. And I felt that the defendant had been drinking, and I don't believe that he was believing me when I was telling him no.
Objection to the drinking comment. Objection to the drinking comment here. She said she felt that the defendant had been drinking. That would be call for speculation, and this is a narrative. The question was asked a long time ago.
Thank you. So, Ms. Reiser asked to the speculation and narration.
I can clarify on the drinking part, but I do. So, Ms. Nelson, before in the room and going to the bathroom and those steps you took after that, Did he actually penetrate you with a part of his body?
Yes, with his penis.
Into what part of your body?
My vagina.
Okay. And were you continually telling him to stop?
Yes, I was telling him to stop. I was telling him this isn't what I wanted. I was telling him I was continuing to push him off of me, or at least attempting to. Yeah.
Okay. And you mentioned that you thought he had.
Okay, so I just wanted you to hear how clear her testimony was. Her voice wasn't cracking. She wasn't sad or crying. She was clear. She was prepared to tell her story. So she's an excellent example of the witness preparation. Okay. So now I'm going to jump quite a bit ahead to the end. And I want you to hear a little bit about when they talk about the bond and the alleged text messages and what it says being threatening text messages. I want you to hear that. And the judge actually, she's not aware of all of the text messages. So there is some conversation about that and how they have to lay a foundation for that. So I'm sure they're going to do that in the future, but I just want to hear you. I want you to hear them have that discussion, okay? So let me jump ahead to the end.
One criminal sexual conduct, which is a 15-year felony with mandatory aids and custody. I'm signing an order at this point for the testing.
Thank you.
The trial in this matter would be, well, I guess we need to address bond first.
And Your Honor, I would like to address bond. I believe the defense bond is set at a $50,000 PR bond, and I have serious safety for the victim in this case. As I indicated to Your Honor and to Mr. Gaddy prior to the beginning of the examination, immediately within days of the victim reporting this, she started to receive text messages. The first was on Thursday, May 6th, stating, "We stomping that bastard out of you," within a celebration emoji, presumably referring to the unborn child that she's carrying. The second text received on May 8th said, "You ready to join your daddy, bitch?" And the victim can certainly elaborate on it that her father is deceased. She's continued to receive text messages from unknown numbers that are not traceable, like a spoof number. On June 20th, she received a series of text messages that said, "Tell me how it feels to be your last week alive. Your baby will suffer very slowly after we cut that bitch out of you, and you can't hide." She responded, "All of this is being added to the report that's going to be called on the 20th. Please continue." And the response was, "LOL, wait until we catch you." She received text messages last week on the 16th, and I can certainly let the victim elaborate, but now that she has testified, I'm very, very concerned for her safety.
All right.
Okay, so I wanted you guys to hear some of those threatening text messages. And again, this is alleged. However, I must say that that's not something you ever want to do, is threaten anybody, whether you're on bond or not. But that would be a violation of the bond. You cannot have contact with the victim. You cannot threaten the victim. You can't have other people threaten the victim for you. Okay, and that is alleged. So I'm sure there's going to be some hearings on that, and maybe some additional charges for witness intimidation, because that is what it's called. It's intimidating a witness. So that could possibly be additional charges added to whatever charges is already against the defendant. Now, The last thing I wanted to go over and state on the record, they actually talk a little bit more about the threats and how they are going to look into this witness intimidation. So let me play that. Alleged witness intimidation. Okay, so let's play that.
In response to Mr. Hill's lawyer saying that none of them came directly from his number, that is not true. In the very beginning of this, I did get a text message directly from Mr. Hill, and it stated, "You a foul bitch, and you better hope the police catch him before I do."
Object to this testimony. The text messages that I've been informed of and that I've received are two that were in the police report and one that was sent to me today. I have no prior knowledge of this text. Of any text that Ms. Nelson is speaking of.
Ms. Weiser, has that information been shared, Mr. Gannon?
I will, Your Honor. There's going to be a separate investigation for witness intimidation. So as soon as I have it prepared, I'll send it to him.
My question was, have you shared it prior to this moment so that he's aware of this text that apparently Ms. Nelson is testifying about?
Okay, so I just wanted you guys to hear what the prosecutor said. There is going to be a separate investigation into the witness intimidation. So they're going to take that information, give it to police officers, try to trace and track down those numbers, which she said was spoof numbers, but they do have numbers in the beginning that allegedly came directly from the suspect. So that will probably be an additional charge of witness intimidation. So again, that deal prior to the preliminary hearing was a great deal. 1 year in jail, which he's probably not going to do. I would be surprised if he did 3 or 4 months. People with those short sentences, they don't really do 1 year, maybe 90 days, something like that. And then again, he would have to register as an S offender. He'll probably be on probation for a period of time. But he was not accepting of that. He did not want that. So now again, there's probably going to be an additional charge of witness intimidation. And then if he is convicted of the S assault, that is a violent crime. This is a pregnant mother. He might be looking at 10 years in prison, and he'll probably do 7 to 8 of them. So I'm not sure the conversations him and his attorney had, but that was a great deal in my opinion. So the whole goal was to get you guys to see kind of behind the scenes what happens in the preliminary hearing and how the witness should be prepared, should be professional, should be clear, be able to answer yes or no, try to keep the personal feelings out of it, stay focused. She was just an excellent witness. So I hope if you have time, you check out that video. Okay. So thanks for checking out this video. I hope to see you in a future video. I want you to stay smart, stay savvy. Have a beautiful weekend, friends. And I will see you in the next video. Okay. Bye, everybody. Have a beautiful weekend. Enjoy this nice weather. Bye. Bye, friends.